Out of the reference guide to regulatory compliance, I'm now going to read OFAC. I'm reading it out of the newer version. So it's PDF page 900. Not showing up right now. 938. The Office of Foreign Assets Control, an agency of the U.S. Department of the Treasury, administers and enforces economic and trade sanctions based on U.S. foreign policy and national security goals. Sanctions are enforced against targeting foreign countries, regimes, terrorists, international narcotic traffickers, those engaged in activities relating to the proliferation of weapons of mass destruction, and other threats to the national security, foreign policy, or economy of the United States. OFAC acts under presidential national emergency powers as well as authority granted by specific legislation to impose controls on transactions and freeze assets under U.S. jurisdiction. The targeted countries change periodically on a basis of presidential and congressional action. Currently, OFAC enforces the regulations implementing the following statutes and Executive Order 12978, which targets known international drug traffickers. Then we have a list of our big regulations. Our biggies and goodies. I hope it's updated because this can change frequently. Not these regulations per se, but the countries and the persons on the list change on a daily basis. Sometimes less frequently. Let's start with Trading with the Enemy Act in North Korea and Cuba. International Emergency Economic Powers Act involving Iraq, Serbia, Montenegro, Bosnia, UNITA, which is Angola, Sudan, Iran, and Burma. The Iraqi Sanctions Act. The United Nations Participation Act involving Iraq, Serbia, Montenegro, Bosnia, and UNITA, also called Angola. The Cuban Liberty and Democratic Solidarity Act, the Cuban Democracy Act, the International Security and Development Cooperation Act involving Iran, the Iran Sanctions Act, Anti-Terrorism Act and Effective Death Penalty Act in Cuba, North Korea, Iran, Iraq, Syria, and Sudan, the Foreign Narcotics Kingpin Designation Act, the Executive Order blocking property and interests of specified parties related to former leaders of Yugoslavia, Executive Order blocking property and prohibiting transactions with persons who threaten to commit or support terrorism, Executive Order blocking new investments in Burma, Executive Order blocking transfers of persons who threaten international destabilization in the Balkans, and Executive Order blocking property of certain persons and prohibiting the export of certain goods to Syria. OFAC regulations prohibit specific transactions with targeted countries and individuals or entities known to be acting on behalf of the targeted countries. In some cases, accounts of specified entities must block and then be reported to OFAC by the financial institution. In addition, the transaction control regulation prohibits U.S. persons from brokering or financing exports of strategic goods from third countries to the target countries. All U.S. persons, including U.S. banks, bank holding companies, and non-bank subsidiaries, must comply with the OFAC regulations. The federal banking agencies evaluate OFAC compliance policies, procedures, and processes to ensure that all banks subject to their supervision comply with the sanctions. The agencies have issued... I'm seriously having trouble scrolling. Issued a chapter on OFAC compliance in the BSA examination manual. Enforcement responses to OFAC violations are determined by OFAC and explained in this guidance. Economic sanctions enforcement guidelines as well, which was last updated in November of 2009. Subpart 1 includes definitions of a blocked account and a national, as well as specially designated nationals. Blocked account is any account in which payments, transfers, or withdrawals or other dealings may not be made without authorization from OFAC. A national is a subject or citizen of a country or a person who has lived or has been a permanent resident of a country since the effective date. 2, a corporation. It can also be a national and also a partnership or any other organization that has had a principal place of business in a foreign country or has been controlled by a foreign country since the effective date. Specially designated nationals are persons who are considered to be nationals of a target country. They are known to be acting on behalf of a target country or are associated with international narcotic trafficking or terrorism. Those on the OFAC list of specially designated nationals and blocked entities also includes blocked vessels, which a vessel is a ship. Property and property interests, anything of value, including but not limited to money, deposits, notes, stocks, bonds, securities, bills of lading, bankers' acceptances, evidence of ownership, mortgage deeds, real estate, goods, accounts payable, negotiable instruments, safe deposit box contents, personal property, annuities, powers of attorney, contracts, and so forth. Property interest is any interest whatsoever, direct or indirect. Subpart 2 is the general prohibitions. All property and interest in property of North Korea, Sudan, Cuba, UNITA, persons considered to be foreign narcotics traffickers, and any person listed on any applicable executive order, their agencies, instrumentalities, controlled entities, and specially designated nationals in the United States or within the possession or control of U.S. persons are blocked. Property and interest in property of all former Iraqi government entities remain blocked, but beginning in 2003, some specified Iraqi state bodies operating under the authority of the coalition government were unblocked. In 2004, the president lifted all sanctions against Iraq, and some licenses must be obtained to export goods to Iraq. Many of the assets of former Iraqi's regime are still on the SDN list. Performance of contracts in certain countries that would benefit that target country, and transfers of funds of any financial institution by U.S. persons to Cuba and Iran governments or nationals are prohibited. Transfers to certain Cuban nationals are allowed up to $300 in a 3-month period and up to $500 for immigration assistance, immigration with an E. Let me just go back up to letter B for a second. I was scrolling too fast. Those countries were Burma, Sudan, and North Korea, prohibiting financing to a company whose services would benefit a project in the target country. After June 19th of 2000, persons in the United States may export goods to North Korea under a license. Goods may be imported from North Korea with prior approval of OFAC. Property related to North Korea that was blocked as of June of 19th of 2000 must remain blocked. Letter E. Banks must reject transfers of funds from the government of Syria or the government of Sudan unless the rejection would further terrorism in the United States, in which case the bank should accept the transfer and hold the funds. Banks may not finance transactions involving confiscated property in Cuba if the ownership of the property is claimed by a U.S. national. Letter G. Payments on a standby letter of credit in favor of Iran or Sudan are prohibited, except to the blocked account. U.S. financial institutions may not advise on a letter of credit. In September of 2008, OFAC added Iranian vessels to an SDN list designated under the Proliferation of Weapons of Mass Destruction designation. Estates of Cuban heir. Oh my God. I'm scrolling way too fast. Okay. Heir, resident is, okay. Estates in which a Cuban resident is an heir or the deceased are blocked. Letter I, safe deposit boxes are blocked if a Cuban has an interest in a property contained in the box. J, new investments in Burma is prohibited. A license was issued in 2003 allowing small transfers to of money to Burma limited to $300 per household. Letter K, in 2006, the U.S. government determined that Hamas was a terrorist entity and blocked all transactions with the Palestine Authority except those authorized by special license. In 2011, Iran was designated as money laundering jurisdiction. Since 1996, sanctions have been imposed against Iran, and subsequent amendments to the Iran Sanctions Act have cut off the Iranian banking system from SWIFT. These laws have also prohibited the transfer of certain precious metals and advanced technology to Iran, as well as goods related to energy production, weapons development, or shipbuilding. The facilitation of these activities by financial institutions prohibited. OFAC publishes a list of foreign sanctions evaders. This is a list of foreign persons who have violated, attempted to violate, or conspired to violate the sanctions against Iran or Syria. The list also includes persons who have facilitate deceptive transactions for or on behalf of persons subject to U.S. sanctions. Subpart 3, reporting requirements. All reports on blocked accounts or rejected transactions must be sent to OFAC within 10 business days of the occurrence. Information required to be sent on blocked assets includes the identification of the property, the owner of the account, the property address and location, the account number, the value of the account, estimated or actual blocking date, a photocopy of the transfer or payment instructions, confirmation that the funds have been deposited into a blocked account, the identity of the individual or entity subject to blocking should be clearly identified, and the name and phone number of compliance personnel at the bank who have knowledge of the transaction. Subpart C, under record keeping, information on rejected transactions includes name and address of the financial institution requesting the transfer, date and amount of the transfer, photocopy of the transfer or payment order, reason for rejection, name and telephone number of compliance personnel at the bank who have knowledge of the transaction, and D, if the transaction should have been blocked or rejected. OFAC may send a letter requesting information on how the transaction was processed. The bank has 30 days to reply and request no penalty or a reduction in penalty. Letter E, an annual report on blocked accounts as of June 30th of each year must be filed by September 30th. As of June 30th. Filed on September 30th. All blocked accounts must be placed in an interest-bearing account earning interest at a commercially reasonable rate, that is, a rate currently offered to other depositors on deposits or instrumentalities of comparable size and maturity. No right to set off is permitted against these funds. And banks must keep a record of each rejected transaction for at least 5 years after the date of the transaction. For blocked property, records must be kept for the period of time the property is blocked and for additional 5 years after it has been released. Licenses, Subpart 4. OFAC issues general and specific licenses for specific exemptions from the general prohibitions. B, applications may be made to OFAC for specific exemptions from the general prohibitions. Application may be made to OFAC for a license authorizing certain transactions. 1. The applicant must make a full disclosure to OFAC of all interested parties to the transaction, and 2. Persons acting under authority of a license are subject to various reporting requirements as specified in the license. Roman numeral 5, compliance responsibilities from OFAC's Foreign Asset Control Regulations for the Financial Community and Industry Summary is where these compliance responsibilities are sourced. A, banks are responsible for developing a compliance program and internal audit procedures to block and report all covered transfers. B, in case of a violation, OFAC considers the following actions favorably. That's 1, the use of interdiction software, and the use of good faith manual and electronic compliance efforts. Banks should designate a compliance officer for OFAC regulatory compliance. In-depth audits should be conducted annually. Compliance training and updating on OFAC requirements should be conducted throughout the organization. And records and reports makes up subpart 6 of the OFAC regulations. A, records of each transaction must be kept for 5 years. B, records must be made available to the Secretary of the Treasury on request. C, holders of block property must register with OFAC within 10 business days after such property is received or blocked. D, annual report on block property held as of June 30th must be filed by September 30th. And the penalties, Section 7 to the Iraqi Sanctions Act is 12 years in prison and $1 million fine for corporate criminals. Individual criminal penalties is 12 years in prison and a $1 million fine, and civil penalties is $250,000 per violation. For the Cuban Democracy Act, corporate criminal violations are 10 years in prison and $1 million fine. Individual criminal penalties are 10 years in prison and a $250,000 fine, and the civil money penalties are $55,000. Cuban Liberty and Democratic Solidarity Act for corporate criminal penalties. There's 10 years in prison and $1 million fine. Individual criminal penalties is 10 years in prison and a $250,000 fine. And the civil money penalties are $55,000. International Emergency Economic Powers Act. Criminal violations for corporations is 10 years in prison and $1 million fine, whereas for individuals it's 10 years in prison and $250,000 fine, and civil money penalties are $55,000. I'm sorry. Corporate criminals 10 years in prison and $500,000 fine. Individuals is a $250,000 fine or 10 years in prison. Civil actions is $11,000 per violation, and civil money penalties is also $11,000. Trading with the Enemy Act for corporate criminal penalties is 10 years in prison and a $1 million fine. For individuals, it's 10 years in prison or a $250,000 fine and $250,000 fine. Civil money penalties being $55,000. The United Nations Participation Act, again, 10 years in prison for corporate and individual criminal fines. However, the fines are $500,000 and $250,000 respectively. U.S. Criminal Code violations for falsifying or concealing material facts is $10,000 fine to corporations. Individual persons could go to jail for 5 years. Anti-Terrorism and Effective Death Penalty Act violations, criminal violations for the corporation are 10 years in prison and a $500,000 fine, or for individuals 10 years in prison and $250,000 fine, and civil penalties are the greater of $50,000 or twice the amount that should have been blocked. The Foreign Narcotics Kingpin Act, criminal penalties for a corporation is up to a $10 million fine. For individuals, 30 years in prison and a $5 million fine. Civil penalties are up to a $1 million fine. Iran Sanctions Act is $250,000 or twice the value of the transaction, whichever is greater. Criminal penalties of up to $1 million and or 20 years in prison. And failure to furnish information, OFAC Enforcement Guide. Appendix 4 tells us the failure to respond to an OFAC request to furnish information or failure to furnish the information up to $20,000, regardless of whether a violation is a statute or a sanctions program is alleged. And if OFAC has reason to believe the transaction value is at least $500,000, the failure to respond or failure to furnish may result in a fine up to $50,000, regardless of whether a violation of a statute or a sanctions program is alleged. The late report filing. OFAC enforcement guidance. Appendix A4 tells us late filing of a required report may result in a fine up to $25,000 if filed within the first 30 days after the filing deadline, or up to $5,000 if filed after the first 30 days after the filing deadline. Okay, so within the first 30 days and after the first 30 days. And if the report relates to blocked assets, an additional $1,000 may be imposed for every 30 days the report is overdue up to 5 years. The failure to maintain records, also according to the OFAC enforcement guidance, the first failure to maintain required records may result in a fine up to $5,000. Each additional failure to maintain records may result in penalties up to $10,000. That's not really all that much. That's not really motivating people to keep records, is it? Enforcement. No possible OFAC responses to apparent violations. Did I say no? I meant to say possible OFAC responses to apparent violations can result in no action. If OFAC determines that there is insufficient evidence of a violation or the facts and circumstances do not warrant action. Possible OFAC responses to apparent violations for information requests. OFAC may request information on the apparent violation from the subject or third parties. And a cautionary letter from OFAC. If OFAC does not believe there is enough evidence to warrant action, or if the facts do not rise to the level of an enforcement action, but OFAC believes that the underlying conduct could lead to a violation in the future, may issue a cautionary letter. conveying its concerns about the conduct or the institution's policies and procedures. OFAC could issue a finding of violation if OFAC believes a violation has occurred and wants to document the occurrence and respond to the violation, but does not believe the civil money penalty should be assessed. It can issue a finding violation. The finding of violation identifies the violation and conveys OFAC concerns about the subject person's policies and practices, and identifies further compliance steps that should be taken. Civil money penalties can be warranted in accordance with enforcement guidelines, and criminal referrals, if appropriate, under certain circumstances. OFAC may refer the matter to law enforcement agencies for further action, and other administrative actions include license denial, suspension, modification, or revocation, cease and desist order, and that is issued when the behavior appears to be ongoing. Subpart B, under enforcement actions is factors relating to administrative action. The type of enforcement action pursued depends upon an analysis of the so-called general factors, including willful or reckless violation of law. OFAC action will be stronger for willful misconduct or deliberate action. This factor considers whether there was a decision to deliberately violate the law and the demonstration of reckless disregard for U.S. law, the deliberate concealment of the circumstances, any pattern of misconduct, or prior notice given to the subject person, and management involvement. 2. The awareness of conduct is also a general factor. The greater the subject person's knowledge of the conduct, the stronger the enforcement action will be. This factor considers whether the subject person had actual knowledge of the conduct. If there was no actual knowledge, whether there was reason to know of the conduct, and management involvement. Harm to the sanctions program. The actual potential harm to an OFAC sanctions program will be considered when assessing an apparent violation. This factor includes the economic benefit to the sanctioned person or country, the implications for the U.S. economy, whether the conduct would have likely been licensed by OFAC, and whether the conduct was in support of humanitarian activity. Individual characteristics considered are commercial sophistication of the subject person, the size of operations and financial condition, the volume of transactions, sanction history. Compliance program is considered a factor. The subject person's compliance program will be taken into consideration. The remedial response also to be considered is the steps taken or processes followed upon learning of the conduct, and were new and more effective internal controls implemented, and was a review undertaken to determine whether other possible violations have occurred. Cooperating with OFAC factors include when the subject person self-reported the violation, whether the subject person provided all relevant information to OFAC, and whether research conducted for all other violations was provided to OFAC, whether there was a voluntary disclosure or a response to a subpoena, whether there was cooperation and prompt responses during the investigation, and whether the subject person agreed to a waiver of the statute of limitations. Timing of violation in relation to the sanction, whether the violation took place shortly after a new sanction program or a new name was added to the SDN list, and other enforcement actions considered whether other enforcement actions have been imposed by state or federal agencies for similar violations. Future compliance and deterrence effect, considering the imposition of an enforcement action deterred future violations, and other relevant factors on a case-by-case basis. Determining CMPs. The enforcement guidelines provide a new process for determining the amount of a civil penalty. First, a base penalty amount is determined based on 2 considerations: whether the conduct giving rise to the violation is egregious or non-egregious, and whether the case involves a voluntary self-disclosure. Voluntary self-disclosure reduces the base penalty by about 50%. The existing definition of voluntary self-disclosure has been changed. Formerly, the definition stated that notification is not voluntary if OFAC previously received information from another source, if notification would have been given by another institution blocking or funds rejected to report whether or not received, or if notification is in response to an administrative subpoena or an information request. The new definition also includes definitions that add false or misleading information, material incomplete disclosure, disclosures made by anyone in the subject organization without authorization by senior management, and the new definition also requires that voluntary self-disclosure be disclosed within a reasonable period of time by a report of sufficient detail to afford, oh my god, I just scrolled up so much, to afford what? A complete understanding of the apparent violation. Egregious cases are defined as the most serious sanction violations based on analysis of the general factors, giving substantial weight to whether the violation was willful or reckless, or whether the subject was aware of the violation, harm to the sanctions program objectives, and individual characteristics of the subject person. A determination that a case is egregious will be made by a director or deputy director of the OFAC. The civil money process starts with a pre-penalty notice. OFAC will issue a pre-penalty notice if it has reason to believe a violation has occurred and a civil money penalty is warranted. Content being a description of alleged violations, including the number, identify the regulatory provisions allegedly violated, identifying the general factors most relevant to the determination of the proposed penalty amount, identify the maximum statutory penalty, reflect the OFAC's preliminary assessment of the penalty, information about how to respond, a statement that failure to respond will likely result in an imposition of civil money penalty and amount equal to that set forth in the notice. If, based on receipt of additional information, this assessment increases more than 10%, OFAC will issue a revised pre-penalty notice. Response to pre-penalty notice: A subject may file a written response. B, emphasis of the response should be on a discussion of the general factors. And 1 and 2, 1, penalty notice constitutes a final agency finding that a violation has occurred. Other general factors, the penalty amount, and the penalty notice will take into account relevant additional information provided in response to a pre-penalty notice. Third, in the absence of a response, the penalty amount will generally be the same as set forth in the pre-penalty notice. Imposition of CMP creates a debt due to the U.S. government, and OFAC refers cases not paid within the time prescribed in the penalty notice of the Department of Treasury's Financial Management Division for collection. I think that's finally it. It's ridiculous that this section's application of civil money penalties and is longer than the content of the regulations giving rise to the civil money penalties. Nevertheless, we're ending on page 928.